This lecture is the first of several on trademark subject matter. What can serve as a trademark? Now, in practice, there are not too many limits. For example, the Lanham Act defines a trademark as any word, name, symbol, or device, or any combination thereof, used to identify and distinguish goods from those sold by others, and also to indicate the source of the goods or services in the case of service marks. So this means that the potential scope of what may serve as a trademark is quite broad, so long as it is distinctive. The idea here is that marks like these serve the trademark purpose of enabling competition in price and quality, so consumers can reward the winners of that competition by finding them in the marketplace. So trademarks can be word marks like Apple Computer, logos like the Apple, the VW logo, the golden arches, colors like this puke green shade on dry cleaning press pads, which, as we're going to see, was the subject of actual litigation before the Supreme Court. Sounds like the NBC chime or the Homer Simpson "No!" And trade dress, both in the form of product packaging and also things like product design, and we're going to cover those in much greater detail in later lectures. So let's talk a little bit about what it means to be distinctive, what it means to perform the trademark function of identifying and distinguishing goods and services. And for now, we're just going to focus on word marks. As we'll see, the law splits word marks in two categories. Some marks, those that are fanciful, arbitrary, and suggestive, and we'll discuss those terms in greater detail in the next lecture, are treated as inherently distinctive. That is, trademark law automatically assumes that when used as a mark, these words perform a trademark function. That is, when you see Apple as Apple Computer, you automatically assume that Apple functions as a brand name. Other words, descriptive marks, like tasty salads, have to prove it. They don't get protection unless the user of the mark can show that consumers actually use the word as a trademark, that the words have actually acquired distinctiveness in the marketplace. Now, this split between inherently distinctive and non-inherently distinctive marks highlights a couple of interesting things about trademark doctrine that are going to come up multiple times over the course of these lectures. First, trademark law makes all kinds of assumptions about how our minds work. For example, judges assume that consumers automatically use inherently distinctive terms as trademarks, but courts came to these conclusions without any kind of empirical study. And as we'll see, trademark law has a lot of intuitive, casual empiricism of this sort that may or may not actually correspond to what we would find if we were to expose the assumptions of judges, who are not neuroscientists, to empirical analysis. Second, the rules of trademark law reflect values other than getting consumer perceptions correct. That is, trademark doctrine cares about more than basic accuracy. For example, why does the law let some trademark holders get away with simply assuming that their marks are distinctive and give them automatic protection? You can imagine a world in which you would require all trademark holders to establish that the trademark is actually performing a trademark function. That is, before Apple Incorporated could get a mark for Apple computers, it would first have to show that consumers actually use the Apple trademark to identify and distinguish computers and later smartphones and the like. But would that be a good use of judicial resources? Would the game be worth the candle in that situation? Or is life simply easier if we assume that arbitrary terms juxtaposed with products function as trademarks? If it is in fact empirically the case that most inherently distinctive marks are in fact performing the trademark function, then maybe it would be a waste of resources to require would-be trademark holders to show that their marks are actually doing the job. Now note, we could even ask the reverse question of descriptive marks, for which trademark does require a showing of what is called secondary meaning, a demonstration that consumers actually use the term to identify and distinguish the good or service. We might ask whether this secondary meaning inquiry produces results that justify the effort. Third, and in keeping with the idea that values beyond consumer perception matter, we might ask what the consequences are to competition of allowing or not allowing certain kinds of words to be trademarked. As we'll see, maybe that issue is significantly more important than questions of simple distinctiveness and consumer perception. Now, we'll begin to unpack that issue in the next lecture, which concerns the Abercrombie spectrum, which is the classification framework that trademark law uses to assess protectability of word marks. Thanks for watching.